one side of the case and take 6 different kids and try the other side of the case. And if that works for them, that's great. Maybe getting them thinking just on one side of the case works well for them. We tend to think that having them work on both sides works to their disadvantage. To their advantage, because they can understand what they're trying to do on each side and they can understand what the attorneys are trying to do. But we also will have times, because of our numbers, where we may use a person only on one side of the case and not the other, and we want to get more kids involved. So we don't have a hard and set rule, and we also are willing to make changes after we do the initial tryouts. We try hard not to do too much of that because we want the kids to bond as a group, as a team. But there are times when you just have to flip-flop kids from the JV and varsity and vice versa, depending upon what their willingness is to commit or how they perform. We also have conversations with the kids before tryouts about the commitment level of attorneys versus witnesses. And here's what my conversation with them is. How many of you have seen that movie Cool Runnings, the Jamaican bobsled team? A lot of the kids, even though it's a little older now, have seen that movie. And there's a scene in that movie where the one guy who is the go-kart driver wanted to be the driver of the bobsled team. And there was a conversation between John Candy and this guy, and he said, if you are the driver of the team, then when everybody else is in the bar drinking beers and having fun, you're sitting around looking at photographs and videotape. When everybody else is doing this, you're studying the run. You're analyzing the sled. You're doing this. You have the lives of your teammates in your hands. And he goes, you can let him do it. and that's sort of the conversation that we have with the kids about being attorney versus witness. When you're attorney, you score more times than the witnesses do. Although we do tell the witnesses that if they do well, not only can they score better, but they can have the attorney cross-examining them score worse. So they can actually affect 2 scores, so they don't feel like they're being left out. But the attorneys have a greater commitment level. And we have a day a week where it's an attorney-only practice with our actual attorneys. The students, the witnesses aren't even there. Because they have to learn the rules of evidence, and they have to learn how to apply the rules of evidence. And so we tell them right off the bat, if you're one of those people who's involved in this club or that club, or you've got these conflicts, you can't be an attorney. The attorneys have to be the ones who are committed, number one, to mock trial. And witnesses we can be a little more flexible with, but attorneys, we need you guys and women there. And that's worked well for us. The other students, we will start out at 1 day a week, and then it increases as we get closer to the competitions. We start out with a varsity and JV together, and then as the season progresses, we split them off into 2 separate teams. So we work them as a group together at the beginning, and then at some point in time, they're going to have to develop their own case themes and strategies, so we split them off. But one of the very first things we do in the practice is we have to have students learn to think like lawyers. And we have to have them get into the case and understand the case. So we'll have group sessions where we analyze affidavits, and their job is to try to select facts out of these affidavits that help the prosecution or help the defense. And it's a good task no matter whether you're a witness or an attorney or anybody. Students will, their first involvement in mock trial, they kind of pick in their head which side they're on, and then they think that way. And we got to get them thinking that there's another side. And so our first practices as a group involve everybody who's analyzing the affidavits and trying to figure out what's important for each side of the case. And we do that before we even ask them to start developing their case themes or strategies. Because how can they develop a theme until they understand what the strengths and weaknesses of each side are? So after we've gone through the affidavits and the materials, then we will then, and we're working separately with the lawyers along the way, we will then have the kids separate off into their two separate groups and then start working on their own individual case themes. They have to have case themes. And if you read in the mock trial materials, one of the judging criteria is there a clear case theme for your school? And the case themes help dictate everything that you're going to do. Sometimes, and we've had some really aggressive student lawyers in the past who know the rules of evidence inside and out, and they hear something being said, and they think, that's objectionable, I'm going to object because of this and this and this, and they don't realize that that was a fact that we wanted in our case. But they said, it's hearsay, so they just had to object because it's hearsay. And we're saying, well, wait a second, why are you objecting? We want that in our case. That's a part of developing our theme. So the kids need to learn that there's a time and place for everything. You need to learn to object when they're trying to get things in that don't help your case theme, and not object if it helps your case theme. And you don't want to object to it over here on the one side of the case and then try to introduce it as evidence when you're putting on your case. Because the judges who are judging you are saying, well, why did you object over there? And now you're trying to get in and over there. That doesn't make sense. And then that person is going to be scored down because of that. So they need to be thinking case theme. It's kind of like, do you have a 3-4 defense or a 4-3 defense? And if you do one versus the other, that's going to dictate, what you do in different situations. So you need to have them thinking about that. And those case themes are what you can try out in your scrimmages. If they work, great. If they don't work, that's fine. Now, here's another thing that I think is a dilemma for all coaches, attorney coaches, teacher coaches, and that is, what level of involvement should I have in helping the kids word their questions? And I've been up against schools where, and I'm not going to name schools, but we've had the varsity and the JV from the school compete against us on the same side of the case, and literally the exact same openings, the exact same closings, the exact same direct questions, and the same cross questions. And you're going, come on, what's going on here? Well, I think you can only get so far by doing that. I think if you want to get to be a top-level school, your kids need to understand for themselves what they're doing here. And we make the kids put together their own questions and their own responses, and we let them try those out. And by trial and error, they're going to find out that this works, this doesn't work. If you do it for them, they won't understand. They won't assimilate that into their thought process. And then if another school comes up with a case strategy that doesn't match yours, they're dead, because they're going to have their little script that they're going to follow, and they're not going to be able to adapt to what the other side is doing. The really good teams know that the questions that they had prepared might not work if the other team brings in a different case theme or a different strategy than what they expected. The really good teams have to be able to respond to that. Now, if you've sat down and wrote out questions for them, they can't do that because they don't even understand why the questions are being asked. So our goal, and I think the whole goal of mock trial, is to teach the kids. Let them get involved. Let them learn how to be lawyers. Get them excited about doing this. And they take ownership in what they're doing. Let them do it, and then work with them to help them accomplish their objectives. Sure, we have to help them word certain kinds of questions, no doubt. I think I was surprised the first scrimmage that I ever attended for mock trial many years ago, 11 years ago, and I heard a student asking a question, Doctor, do you have an opinion to a reasonable degree of medical certainty as to whether this was a cause of this injury? And I'm going, how the heck did that kid know how to ask that question? Well, obviously, there are times when you need to help them word a question in a way that you know will meet the burden of proving the issue that you have to meet. And there are times when your student will have tried a cross-examination question and it doesn't work and it doesn't work, and you say, how about trying this? And they try that and they go, aha, now it worked. Now they understand. And now if they've got a real, difficult witness, now they're going to be able to adapt, because all of the cross questions that you may have scripted for them may not work for a particular witness. And if they learn and understand, they'll know how to adapt to a witness and think on their feet. And that's ultimately what's going to make the teams, the top teams. They have to be able to think on their feet. So if you go into this with the idea that we're going to just give them a script, not only do I think it doesn't accomplish what we're supposed to accomplish in this mock trial program, I also think you'll get them to a certain level, but not at that high level, because they just won't be able to adapt to the situations that are out there. The best ones are the students that can think on their feet and change as they go. Now, the rules of evidence. There are way more rules of evidence than what they're going to need in the case. So we start with kind of a general description of the rules of evidence, because sometimes there will be a rule that you don't think they're going to need, but they ultimately do need. And you're going to find that you're going to have some students that just love the rules of evidence. It's almost like a challenge that they have on a video game on the computer. And they're just going to eat these things up, and you're going to think, holy cow, this kid knows the rules of evidence better than I do. And that's fine. If they want to do that, let them get into that. We do a general description of the rules of evidence, and then as we learn more and more about what the issues are in the case, then we focus a little bit more on the particular ones that are important to this particular case. And yeah, we do help them in their description of how they apply an objection. But again, same thing. If you give them a script to use and the question that they're objecting to isn't exactly the question that we think was going to be asked when we gave them the script, then they're not going to be able to deal with this question that might have been asked a little bit differently, because they won't understand the rule very well. So you got to get them to understand the rules so that they can make those calls in the middle of a trial, just like the questions, just like the answers, and so forth. And it takes a lot of time. It takes a lot of work. Can you get a team together in a month and do okay at regionals? Yes, I think you can. But if you want to have those kids be at that level where they're going to be in the top 5, and Janel's school took second last year, and she knows what I'm talking about. You got to get them to work and understand in their brain what's happening. Okay, I'm going to leave a few minutes for questioning, but I want to comment about one rule change that we have this year. Let me give you a little bit of background. The number one complaint that mock trial has had about competition in the past has been the rule on scoring scope objections or penalizing for scope objections. That's the